If you're renting your residence when a natural disaster strikes, you will likely have a lot of questions related to your rights and responsibilities. First things first, you need to know that if a disaster strikes while you're renting, your lease agreement is still in effect. You should contact your landlord immediately if there are problems with the unit after the disaster. You should know that Oklahoma law gives you options when a disaster occurs that isn't the fault of the tenant, your family or guests, or your pet. If the dwelling is substantially impaired, you may immediately vacate the premises and notify the landlord in writing within 1 week thereafter of your intentions to terminate the rental agreement. In that case, the rental agreement terminates as of the date of vacating. If the dwelling allows for continued occupancy, you should vacate any part that is no longer usable because of the disaster. In this case, your rent should be reduced in proportion to the amount of usable space in your unit. Another important consideration is what to do if you cannot pay rent after the disaster. First, you should look at your lease to see if it addresses this. Talk to your landlord or property manager about your circumstances to see if you can get a different payment arrangement. If you get approval for this, get that in writing. If you have lost your job due to a federally declared disaster, you can file for disaster unemployment assistance from the Department of Labor's website at www.dol.gov.
Your landlord can evict you for not paying rent. If you receive a 5-day notice of non-payment of rent from your landlord, also known as a 5-day notice to quit, you have 5 days to pay the amount due. It will usually say that unless you pay the rent in full within 5 days, your lease will terminate. Your landlord may send you a 5-day notice in the mail, hand it to you in person, or leave it on your door. You need to pay the entire amount of back due rent within these 5 days, or the landlord is entitled to begin proceedings to evict you. The landlord cannot put you out themselves. Even if you did not pay the amount due within 5 days, they'll need to get a court order to evict you. If you pay within the 5 days, then the landlord must accept it and you can stay in your dwelling. However, if you offer to pay only part of the amount due, the landlord does not have to accept it. If you cannot pay your rent in full within the 5 days, or if you try to pay the back rent after the 5 days, the landlord does not have to accept it. The landlord instead can sue you in court to have you evicted. If the landlord files an action in court to have you evicted, a hearing will be scheduled. You have the right to attend the hearing and tell your side to the court. If the court determines that your landlord gave you a proper 5-day notice and that you did not pay the amount due within the 5 days, the court can issue an order to evict you. The court can also order you to pay the back rent due, plus other damages and court costs. If the court orders your eviction, the landlord can now have the sheriff force you to move out. You will not get your deposit money back because of the past due rent as well.
It's important that you understand that your landlord can begin eviction proceedings even if you can't pay because of the disaster. But they cannot force you to move out if their family member was displaced by the disaster and they want to move them into the unit. So what do you do if you're being served an eviction notice? Your landlord can start the eviction process to remove you from the property and sue you for damages that you may have caused. If you have been sued, the papers you receive will have the name of the court at the top and state your name as the defendant. If you receive this paper, you need to contact an attorney. Please note these 2 important facts. Firstly, you will be served. A sheriff or process server will serve you with a summons that will tell you the court date, time, and place for your hearing. If you are not at home, the papers can be left with anyone who is 15 years or older. You can also receive a summons by certified mail or restricted delivery, which must be postmarked for at least 3 days before hearing date. The summons will also give you a deadline for filing your answer.
Which brings us to the second fact. you must file an answer. The answer is your chance to respond to the landlord's claims, and this must be done by the deadline indicated in your summons. If you need an answer form, the court clerk's office may have sample answer forms. You can also visit oklaw.org for information about landlord-tenant issues. You should write in your answer why you should not be evicted and/or why you do not owe the money the landlord is asking for. You should speak to an attorney before filing an answer. If you do not file an answer, or if you do not appear at the hearing, the landlord may get the eviction approved and any money they are asking for. This is called a default judgment. You will receive a copy of the judgment in the mail. If your landlord is trying to evict you and you do not have an attorney to represent you, make sure you attend the hearing. Bring any relevant paperwork with you, along with any witnesses you may want to testify.
You should also know some reasons that your landlord cannot evict you. Even if you didn't pay your rent, your landlord cannot evict you if your landlord stopped your electricity, gas, water, or other necessary service. Your unit was in such poor repair that the judge believes it should not be lived in. If your landlord is trying to evict you because they claim you have not paid your rent, but you have receipts for your rent payments, take those receipts to show the judge at the hearing. Your landlord may not be able to continue with the eviction if they accepted even part of the rent that is due before you go to court. Your landlord failed to give you the proper written 5-day notice for non-payment of rent and/or 15 to 30-day notice for violating terms of the lease, and/or a proper 30-day notice to terminate a month-to-month rental agreement.
Keep in mind that if you have been evicted by a court and you receive public housing benefits or apply in the future for public housing benefits, an eviction could affect your ability to obtain these benefits. You should contact an attorney right away if you are sued for eviction. If you move out before the eviction is filed due to damage to the home, you need to inform the landlord in writing that you are moving out due to the damage to the home. Provide the landlord with updated contact information. Because you are leaving due to damage, it is a good idea to take pictures of the home before you leave.
You might be wondering, how long do you have before you need to move after a court-ordered eviction? To put it plainly, if you are evicted, you need to move. If the court orders that you are evicted, you need to move out right away. If you don't, a sheriff or officer has the authority to forcibly remove you and your property. This can even happen the day of the court order. Therefore, it is important to move out immediately. If you have been evicted by the court and need to move, get your property out of the unit right away. Even if you do not have another place to live, put your things in storage or move them to a friend's house. If you leave property there, it is often difficult to get your property back, even though your landlord should not immediately throw it out on the curb or throw it away. The landlord must give you a written notice that any property of value not picked up within the time specified in the notice will be deemed abandoned and become the property of the landlord. Any property left with the landlord for a period of 30 days or more shall be determined to be abandoned. You could be charged fees if the landlord must store the property. These fees often add up to hundreds of dollars, so it is important to move everything out when you leave. If you do not pick up your property and pay the fees before the deadline, your landlord can sell it at a public sale or possibly dispose of the property as he sees fit. The landlord may place a lien on non-exempt property belonging to the tenant which has a reasonable relationship as practicable to the amount of the debt owed for the property charges owed by the tenant and for the cost of enforcing the lien, with the right of possession of the property until the debt obligation is paid to the landlord.
If you are displaced because of a natural disaster, you need to know of a few things to watch out for with new rentals after a disaster. Scammers can use rental listings to take advantage of disaster victims. Scammers promise to find people housing if they pay money up front, either by wiring money or by paying a security deposit or first month's rent before you have signed a lease. If you are given a contract, make sure to read it carefully. You can report scams to local law enforcement or to the Federal Trade Commission at www.ftccomplaintassistant.gov. Renters also face the issue of replacing personal property that was located on or in their leased property at the time of disaster. If you had insurance on your personal property, you should check your policy. If you do not have insurance on your personal property, then you are responsible for replacing it. Apart from renters, anyone might have to deal with their personal property ending up on someone else's property. When personal property is carried away by wind or flooding and comes to rest on the land of another, it remains the property of the original owner, and the original owner may enter and retrieve it. If the landowner refuses to let the original owner of the property enter or appropriate the property for the landowner's use, the original owner of the property will have an action against the landowner. On the other hand, the landowner has no obligation to preserve the property and may move the property if necessary to use the land, provided such action is taken in a reasonable manner.
Another common personal property issue after disasters is looting. If you know who stole your property, you can hold him or her responsible. You should file a police report. If you have insurance, you may be able to file an insurance claim. You should check your policy. So, regarding personal property, if you are insured, you should contact your insurance company. If you are not insured, you should contact or visit disasterassistance.gov for potential government assistance for disaster victims. Oklahoma Department of Emergency Management for a list of charitable organizations providing help. Local nonprofits, voluntary, faith-based, and community organizations.